Muted.
Okay, so again, good morning. Thank you for joining us for our webinar about the ICADV Legal Clinic. The purpose in having this webinar was to try and answer some of the questions and confusion that we've been having. Oh, I saw a hand up. Did someone have a question? Okay. And to try to help folks understand what kind of services we offer, what help we can provide, and what information we need from advocates and from clients in order to make those connections happen. We want the webinar, the information to be responsive to what you need, what your questions really are. So if you have a question, please raise a hand or send me a chat, and I will try to address it, and I'll leave time at the end as well. So, ICADV has a legal clinic. It is important that you know this. Our legal clinic is funded by the Legal Assistance to Victims Grant Program. Our purpose is to provide holistic civil legal representation to survivors of domestic violence, dating violence, stalking, and sexual assault. Those are the same categories of folks who you're all serving, so we should have a lot of common ground there. The current grant that we've been awarded runs through 2017. We plan to reapply, and that should be coming up here in the next few months. And hopefully we will be able to sustain the project moving forward, and all the good work that we're doing. Also of special interest and import to you all, as part of the grant, there is a small allowance to reimburse local programs for some of the support that you offer us. Your services and the support of advocates is part of how our services are holistic, how they address the full range of needs that survivors have when they come to us for help. And we know that it takes a lot of energy and time and money to make that work on your end. So we're trying to make a little bit of money available to try and support that work and encourage that collaboration. So right now we have about $8,000 available for local programs working with survivors as they receive legal representation from ICADV. Application for the money is first come, first serve. It can be used to reimburse for mileage when an advocate is going to work with a survivor on her case, or if an advocate is bringing a survivor to an appointment. If the program needs to hire or contract for translation or interpretation services for that survivor to help her with her case, you can apply for reimbursement for that, as well as advocate time. If an advocate is helping a client with her personal declaration, or she is working with her on gathering letters of support or something like that, that advocate time can be billed to ICADV as long as that time is not also billed to another source. So if the advocate position is funded by CVAD, the hours that you send to ICADV cannot be sent to CVAD. A little bit of a financial walkabout there, but your financial folks hopefully can help you figure all of that out. If you have questions about that, please feel free to contact me or Joan, the financial person here at ICADV, and we can help you figure that out. Again, the money is first come, first serve, so when the $8,000 is gone, it's gone. But we have until September 30th of 2017 to use it, so please make use of it. Who is the Legal Clinic? We have a growing staff here at the Legal Clinic, which is very exciting for us. It consists of Carissa Fleggy. She is the director of the Legal Clinic. She is an attorney. She does primarily immigration work. And so you'll probably be seeing emails from Carissa regarding intakes. If you have immigration questions, she's a great person to ask. I forgot to introduce myself. I'm sorry. I'm Liz Battles. I am the director of the Skylark Project, and I am an attorney here with the Coalition. I have been here for several years, and I do primarily family law, so divorces, custody cases, as well as protection orders and housing questions. I also take just general technical assistance questions from local programs. So when you have questions about confidentiality or subpoenas or anything like that, they usually end up on my desk. And I'm happy to help with those things. Some of our new staff, Salome Nengan, just joined our team a couple months ago. She is a staff attorney with the coalition, and so she'll be doing primarily immigration cases, but also some family law. Carissa will also be taking some family law and protection order cases, just a smaller number for in comparison to the immigration. Salome will be based out of our office like the rest of our staff, but she will also be doing some office hours at a satellite location, I believe in Mason City. And the goal there is to cut down on travel time for some of our clients and to help introduce our services to a greater population by having someone physically available in the north. We're trying to increase awareness and make connections with more survivors who are seeking services. Veronica Guevara is another new person on our staff. She started a couple months ago as well. She is an outreach coordinator, and she's also support staff here for the legal clinic. She speaks Spanish, so she provides translation and interpretation services for the legal clinic, and she is working on getting her accreditation with the Bureau of Immigration Appeals, which means that she would be able to be the main person coordinating and representing a client in an immigration application. And Jennifer Anderson is our final member of the team here. She is a paralegal with our legal clinic, and so she does a lot of the case coordination and opening and closing of cases, and she does a lot of our intakes. So if you were a client call, you'll most likely talk to Jennifer. And Jennifer is also working on her accreditation with the Board of Immigration Appeals. So what kind of cases do we take? The cases will be immigration cases. Those are VAWA, Violence Against Women Act, self-petitions, U visas. We also do a little bit of other immigration remedies. I'll go into a little more detail about those VAWA and U visa cases. Under the grant, the majority of the cases that we're taking are immigration cases, and we're doing that in partnership with the University of Iowa. I'll explain more about that further along here. So you'll see we'll get emails from us a couple times a year regarding a push for immigration intakes. We're looking for those year-round. I'll explain about the timing of those case pushes a little later. But we know that there is a huge population of undocumented and battered folks in the state of Iowa who need help. And so we're hoping that we can help them get legal status, which enables them to engage with their community more safely and find some independence and some safe separation from that abuse. And hopefully you all will be seeing some more of those folks as well as they either are pulled in because of legal services, or as you see them, please send them our way to get that help. We're also taking some family law cases. That includes divorce, custody, paternity cases. Again, this is a smaller number of cases in our overall caseload. Those cases are much more time intensive, so we're not able to take on as many of them at once, but we are taking them. Protection orders, we'll do both the initial, the temporary and permanent civil protective order, as well as contempt actions if you have a complicated case where someone's violating an order. And then housing law cases. So if someone's being evicted or there are other housing protections that they need to have an attorney help them request and establish. Again, smaller number of cases there, but we are available, so please give us a call. So, immigration. Please do an immigration intake for legal services if your client has any of the following. If the client is married to a U.S. citizen or a legal permanent resident. If the client has been the victim of a crime reported to law enforcement. If the client has petitioned for and received a civil protective order, or if the client has been involved with DHS and that investigation is because of domestic violence or sexual assault. Those are not the only things that are required for immigration remedies, but those are some of the triggering events that indicate that the client may have a remedy available to her. So if those things come up as you're working with a client, make sure you do an intake, please. And it's also just okay to cover your bases if you're working with someone and she mentions that immigration is a concern for her, whether she thinks she's out of status or she doesn't have papers to begin with. Feel free to do an intake and we can sort out whether she has any remedies available to her or not. Just a quick plug. In the spring, Salome and Veronica will be taking some trips around the state to provide more information about immigration. Advocates are not expected to determine whether the survivor has any remedies available. That's above and beyond. So we can handle that. The information that I'm handling today is a brief overview to help advocates remember that we're available and to know what we're looking for. But in the spring, Salome and Veronica will, and probably I, will go around to give advocates a more detailed training about the process of applying for a VAWA self-petition or a U visa, and how advocates can help with applications. So that training will go into a little more detail about what are the remedies and what's the role of an advocate in helping to put that case together. The U visa. The U visa is intended to protect victims during the investigation and prosecution of crimes, a certain list of crimes, and it was created to encourage the reporting of crimes by undocumented people. We don't want crimes and people to be victimized and too afraid to reach out for help simply because they don't have legal status. That makes our communities as a whole less safe if people feel afraid to report. If the U visa is granted, it's not an immediate green card. It's just permission to be in the U.S. for a number of years. So that's temporary legal status. However, after a certain number of years, after 5 years, if the applicant meets certain qualifications, she can adjust status and become a permanent resident. She can get a green card. The award of the U visa is based on helpfulness. That's the slippery term that immigration uses to determine whether or not someone is eligible. And helpfulness can look like a lot of different things. It can look like calling the police. It can look like giving them information about the crime on up to being a witness. So don't worry about determining helpfulness. That's just for you to know what the technical words are. I see a hand. Is there a question? Trying to figure it out. I see the word question. I don't see the question. SEPA, I see that you sent me the word question. Oh, there we go. If a client wants to remove her protective order, does that affect her U visa application? I'm guessing that you mean the criminal no contact order that's issued as part of the criminal case. And yes, okay, good. So the criminal no contact order that does not change whether or not she's helpful in the case. So if that criminal protective order has been put in place, then the abuser has been arrested and charged with a crime. And so it would be good to help that client fill out an intake application and send it to us. Even if the case is dismissed, if it goes forward and is pled down, if it never moves forward, it could, I'm sorry, I'm getting turned around in my head. The outcome of the charges does not affect eligibility for the U visa. The U visa is based on whether or not the victim was helpful in the investigation and prosecution. And that determination is made by law enforcement or the prosecutor or whoever to say, yes, this person was helpful because the victim provided X, Y, Z during that process. So if she doesn't want the criminal no contact order, she can request that dismissed. That is not part of the U visa determination. So I think that answers it. Okay. Back. All right. So that determination of helpfulness in investigation, obviously law enforcement and criminal cases is the clearest example of someone being helpful in investigation and prosecution. However, the U visa law is written broadly enough that it could also include, for example, DHS is investigating a case, a report of child abuse, whether that's there's domestic violence happening in the home, and so DHS is looking at it to see if the children are safe or harm towards the children. If the victim is helpful to DHS in the investigation of all of that, and DHS is sort of making the roundabout determination that there's domestic violence involved here, that may be a sufficient basis to apply for a U visa. So send us that intake and we'll take a look at it and we'll help the client determine in her specific case what remedy may be available. Similarly, if a client applies for a civil protective order, a 236 order, and the case goes before a judge and the judge makes the determination that abuse occurred, there's been an assault, so we need this order. Technically, potentially, there is a claim there for a U visa. The DHS and the civil protective order routes are less well-traveled roads. They're a little trickier to work out, but that's for us to figure. So if you have a case where you have a client working with DHS or where she's petitioned for a civil protective order and she needs legal status, please fill out an immigration intake and send it our way. We can do the work to figure out whether it's a case where we can help. Okay. One of the big important factors in the U visa case, the abuser's status does not matter. Okay. So he can be undocumented, he can be a citizen, it can be a woman, whatever. Who is perpetrating the abuse does not affect the ability to petition for the U visa. Okay, next step. With the U visa, there's a long wait list. So someone fills out the application, does all of the steps to petition, and we send it into immigration. There is a cap on how many U visas can be awarded each year. And right now, the wait list is so long that they award all of those U visas as soon as the fresh batch becomes available. So, whatever it was, October 1, the list of fresh U visa numbers became available. They took that number off the wait list and they were all used for 2016. What that means is that every new application that comes is being put on the wait list, and those cases have to wait until the following year or however long to be granted the U visa and taken off that wait list. So it's not an immediate relief, but it does offer relief to the survivor. During that period of time, while the client is waiting for USCIS to make a determination, she is in deferred status. So she would be able to get work authorization. She would have protection against deportation. She would be safer if she's able to get her U visa application in the mail. Okay. All right. So another route, another remedy that's available for some survivors is the VAWA self-petition. So what the self-petition is, normally when an immigrant's application for citizenship, for permission to be in the U.S., has to be sponsored and supported by a U.S. citizen or a legal permanent resident. So the citizen or resident has to fill out the paperwork and cooperate with immigration and go to interviews and do these sorts of things to support their partner or family member in that process. Obviously, that's a scenario that's ripe for abuse, right? So VAWA is the safety mechanism to separate the victim's petition from the abuser's control. So with the VAWA self-petition, a survivor can separate her application for a green card, for permission to be in the U.S., from the sponsorship of her abuser. The abuser will not be informed that she is separating her application. He won't be informed about appointments or anything like that if as she moves through that process. So it gives her a way to keep herself safe and remove one of the tools that an abuser uses to maintain power and control. So for the VAWA self-petition, the survivor must be married to a U.S. citizen or a legal permanent resident. So in this case, the abuser status matters very much. Common law marriage counts. So in Iowa here, if you have been living together and holding yourselves out as married, there is no requirement of years. That's a myth. It's just you have to be living together and presenting yourself to the community as married in order to claim common law. Again, that's something we can help sort out, but there are questions on the application, the intake application, to help us figure out whether that would be a claim the survivor could make. For the VAWA self-petition, there is no waiting list. So once she applies and is approved, she gets her benefits. So as part of that, there's work authorization again, and then eligibility for benefits at a certain point. So she may be able to apply for food stamps, things like that, if she needs that kind of support. One last point on the VAWA. Marriage is still the basis for the application, so we have to be able to show a good faith marriage. You know, it can't be something for the purpose of getting some kind of immigration relief. And it has to be within 2 years of divorce. So if the client mentions that she was served with divorce papers or that he was threatening a divorce, make sure to get her intake sent to us right away and make a note of that so that we know there's a time crunch. Other remedies that may be available that we may be able to assist with include asylum, cancellation of removal, removal of conditions, and adjustment of status. This is not an exhaustive list. Essentially, if a client mentions she's concerned about her immigration status, send us an intake with as much information as you can. We will see if there are remedies available. For example, a survivor may mention her partner applied for something, but then tanked the interview on purpose, or maybe he never told her what happened with the application. Send us an intake. There may be remedies available, or we may be able to help her figure out where she is in the process. Asylum cases take a really long time and are very rarely granted. So we will not be taking a whole lot of those cases, but we might take one or two over the next year if we find some strong cases. So again, there are some questions on the intake that try to signal to us when there may be an asylum claim. So just give us as much information as you can there. Adjustment of status is the process by which someone switches from having a visa or a temporary permission to be present to having permanent residency. Typically, when someone is ready to adjust, they've been in the U.S. on a legal visa for several years, so hopefully they've achieved some level of self-sufficiency. If the client has decent income, for example, we may refer her on, but feel free to send us the intake and note if there are any extenuating circumstances. We have taken and will continue to work on some adjustment cases where abuse continues to be an issue or income has been difficult because of abuse, those kinds of things. So the immigration intake form. There's a lot of information we try to gather through the intake. So it's kind of long. It's a lot of pages. You'll need to have some time with the client when she's not feeling in crisis. I'm going to go over some of the questions that may seem a little weird or where we have followed up several times. So other attorneys. We need to know if the client is currently represented so we don't give conflicting advice and so we can use our resources most effectively. So please provide the information about what help did the client ask the attorney for? Like, was it someone she contacted before about a protective order, or did she contact someone about this same immigration issue? Did the attorney accept representation? Did the client give them money? Did the client sign paperwork? Has the representation been terminated? Was there a letter from the client, or I'm sorry, from the attorney saying, we no longer represent you? Is she still waiting for legal aid to make a decision? If the client is unclear about her relationship with a past attorney, we may ask the client to follow up with a letter showing the other attorney does not represent her. Okay? So if the client doesn't have that information right when you're doing the intake, that's fine. Please just give us as much information as you can and know that we may not be able to accept her case until we can sort out what's going on, what's the relationship with this other attorney. Marriage questions. We need to know about the client's marital status for VAWA and U visa. For VAWA, the good faith marriage is a big issue, so we need to know about this marriage, any previous marriages, any divorces, or we need the evidence for the common law marriage. For a U visa, the relationship to the abuser does not matter, but marriage information helps us give immigration a fuller picture of what the survivor has been through. So for U visa, it's not the basis of the application, but it's important information for us to have. Children's information, we'll ask about date of birth, country of birth, all of that. We need to know about the children born in the U.S. and those born outside. In many circumstances, we can include non-citizen children in VAWA and U visa applications. Children born in the U.S. create a strong incentive for immigration to keep the survivor in the U.S., so we need to know their information too. So that helps with a U visa case. If she doesn't have status currently, or if there are some other claims, if it's a cancellation of removal or something like that, we need to know what evidence we have tying her here to the U.S. Relatives information, we ask about what other relatives does the client have living in the U.S., what's their status, where do they live. That's to see if there are other family-based petitions available to the survivor. Those family-based petitions can be slower, but it's helpful to know if there are alternative remedies available. Immigration information. We need to know A number and visa and green card information. This current status information gives us a starting point to understand where in the process the client is already. If the client isn't sure, make a note. For example, he applied for something, but she's not sure what. It gives us an idea that there may be additional information we need to request from immigration so we can understand if she's at point C, we don't want to go and apply for point A. We want to make sure we're moving her towards D and E in the process. Arrival and departure dates and reasons. Multiple trips in and out of the U.S. can add complications to an immigration application, and we may have to file additional paperwork. In extreme circumstances, travel can become a bar to applying for status. So we need to know how to advise the client. The purpose is also really important. It doesn't have to be a paragraph, but we need to have a general idea of why this person went back and forth. Again, we're not denying based on that, but we need to know what we're taking on and what additional information we'll need to seek out. Also, just as a pointer on the side, if you're working with a client who mentions that she has a visa, a U visa, she cannot travel out of the U.S., generally speaking. Okay, we've had that come up in a couple issues, a couple times. So travel is really complicated for people who are in the process of applying for immigration remedies. So make sure that client talks to an attorney before they leave the country. Encounters with immigration. So if the person has come into contact with immigration because of a problem, they were crossing the border without papers, they were working without papers, they were going to immigration court, that can affect her immigration application. We need to know what happened, so please provide as much information as the client has. There's a notes section at the end of the intake application where you can give us a more narrative answer. It's really common for folks to be turned around at the border or told to sign something written in English, which she can't read. Depending on the case, we may be able to ask for a waiver to make it okay to apply for immigration remedies anyway, but we need to know the issue exists. Okay, so those are the why we're asking those questions, and that's the information we need. Good moral character, that's looking at her criminal record, whether she's been arrested or ticketed. That's in Iowa or anywhere else in the U.S. Again, criminal charges could potentially bar the client from applying for relief, but in many cases we can request a waiver as long as we have the information to know that we need to waive it. Okay. U visa, like we talked about, this is a remedy based on being the victim of a particular crime. So DV and sexual assault are the obvious ones, but other crimes can also qualify, especially if they happen in the context of domestic violence, like harassment or burglary. So we need to know, did she report the crime? Was anyone arrested? Did the state press criminal charges? What help did she provide to law enforcement? Acting as a witness is great, but it can also include smaller acts, like, was she the one who called 911? Was she interviewed by the police? Did she give information about where the abuser could be found? If you're able to add any of that information to the intake, that helps us know if we need to persuade the certifier, the law enforcement agency, or whoever to sign off on the helpfulness. Then we have that information to say, look at all she did to help you. If law enforcement has not been involved, there may be another avenue, like we talked about, DHS. Did they investigate based on domestic violence, or did she seek a civil protective order? Finally, just a quick note, the last page of the immigration intake is a notes page, so please give us as full a picture as possible. If anything is unclear or if there wasn't a good spot to ask the question, stick it in the notes. We're making our case decisions based on a piece of paper. It can be really challenging. So anything you think will help us to understand what's going on in a case or why this one should really stand out to us, please let us know. Okay, family law intake. So like I said, we're doing far fewer family law cases just because they are time consuming, and the grant that we wrote, the majority of cases we're anticipating are immigration cases. So we are still taking intakes for family law, but we will not be accepting as many cases. A lot of cases will get bumped to a wait list, which really stinks. I'm sorry about that. We're just trying to use our resources as effectively as we can. So, highlighting some portions of the family law intake. Other attorneys contacted. Probably one of the first questions we're going to double check is, have you called Iowa Legal Aid? Has the client contacted them? Legal Aid has a greater capacity to take cases, particularly family law, so we refer pretty much everybody there to double check. And if Legal Aid says no, if you could let us know why they declined the case. Sometimes they have inappropriate reasons for declining cases, and we may be able to provide some pushback on the back end. Also, we want to make sure the client is checking with Legal Aid about this particular case. Sometimes we've had clients who have been declined in the past for other cases and assume that means that Legal Aid can never represent them in anything ever again for the end of time. So we want to make sure that it's a fresh and current intake referral from Legal Aid. There is some information that we're gathering through the intake that is not part of our case acceptance. It's stuff that we use for grant reporting, or at the end of a divorce, there is a report we have to submit to the Vital Statistics Office, and so we just go ahead and get that information at the start of the case so we have it and we don't forget about it. That includes demographic information like social security number, education, prior marriages, and race. So again, we're not screening based on any of that information. It's just there so we have it if we need to report out on it. The description of the opposing party, that information we use so when we go to court, we can, if we're waiting out in the hall for our client and the opposing party, we can maybe identify when the opposing party walks by, just to help us know what we're looking out for. Language, obviously we need to know if we need an interpreter and what language we need to speak. We are, language access planning, and we are really trying to be cognizant of bilingual advocates and not putting them in that awkward position of having to serve as advocate and interpreter. We do not have a ton of money to pay interpreters, so we may, in a pinch, need to ask an advocate to assist with translation and interpretation, and I'm sorry about that. We're really trying to increase the resources that we have available to help with language access so that we don't have to rely on advocates and put them in the middle. But as part of the intake, please make sure we know so that we can prepare accordingly when we try to contact the client. County of residence. A lot of people read this and it's just a trick of the eyes, think it's country of residence. We're going to go ahead and assume you're in the United States if you're sending us an intake. We need to know the county that you live in so that when we file, for example, a divorce, you have to file in the county where you reside. A protection order, you can file where either the protected party or the defendant resides. So we just need to know where is the action happening. And then towards the end of the family law intake, there's a question, client is seeking help to. This question is for us to know what goals the client has for the case. Is she drawing a hard line on sole custody? Is she adamant that he not have visits? Is he currently in agreement on everything and she just needs it finalized? It gives us an idea of the client's mindset and goals. We may not be able to deliver what the client wants most. Zero visitation almost never happens. But it gives us an idea of whether her goals are something we can help her attain, whether the courts are not therapeutic. It would be awesome if they were cathartic and provided an outlet for a survivor to be validated and have the abuser raked over the coals and told that his behavior is abhorrent and all of that. Doesn't usually happen. So we need to make sure that for the client's well-being and her progression towards safety, that what services we're providing are going to respond to her needs. So making sure that the remedy she's seeking is something that the court can actually give her, something that our services would be useful in helping her achieve, all of that. Okay. Okay, some of my notes pages did not print. This will be interesting. Criteria for acceptance. We accept cases year-round. Okay, so if you have a client who is needs help, send us an intake as soon as you can get through the intake with the client. Okay. The client needs to be a survivor who is living in Iowa. There has to be a remedy available under our grant funds. So, for example, we are not able to help with cases where the main issue is child sexual assault. The client seeking services needs to be an adult, or I think the cutoff is like 16 or something like that. So it has to be something that our grant funds cover. Income is a factor that we look at. We don't have a hard line on it. Basically, we're looking at whether the income precludes the client from hiring a private attorney. So, we haven't seen that be an issue in a lot of the family law stuff that we've received. I know family law cases are insanely expensive. But for example, the adjustment of status cases, those applications are not as costly. So if a client has a steady income, we may refer her on to another immigration attorney so that folks who are indigent and are in crisis, we're able to help them. Case capacity will be another issue that we look at when we're determining whether or not to accept a case. How many cases do our attorneys have at the moment? What schedules look like? Do we have room to squeeze in another client? We want to make sure that whatever client we're helping, we're able to dedicate adequate resources, time, energy, brain space, so that we're providing good services. We can respond in a trauma-informed way and really listen to that client so that she feels heard and so that it's not just a paper-pushing process. Lethality and level of danger, particularly in family law cases, we'll look at the level of abuse that's reported when we're determining which cases, where to devote our resources. So like when we're looking at our wait list and trying to see which case to take off of the wait list, we'll look at how long a person's been on there. We'll look at what's the level of danger, how far into the case will this have gone. It's sort of a mix of all of those things that we're trying to figure out which is the case that we should go to next. So it won't be, having the next up on the wait list. It's not a hard and fast process. It's sort of a gut check, which I'm sure is infuriating for you. So I'm sorry about that. There's not really a sense of predictability that we can give around when we'll take cases off of the wait list or which case will be next. But those are some of the criteria we look at. Okay. I don't know why it just paused screen sharing. I'm sorry, hold on. Okay. Sorry about that. Okay, so can you see my slides again? Hopefully. Okay. Okay. Sorry, it looks like there's a question I'm trying to figure out. Okay. Somebody's just letting me know that you can see. Thank you. Okay, so the wait list. Goodness sakes. So as I was just saying, family law cases go on the wait list if we're unable to accept them right then. So it's growing with each referral we get. We have, like I said, 3 attorneys. Salome and Carissa are full-time working on cases. I am just part-time working on cases. The other half of my job is working with incarcerated survivors and running the scholarship program. So the resources that we have to devote to family law cases is a little more limited. The majority of cases that we have under the grant are immigration. So all of those factors are at play when we're figuring out which cases to take. If we're not able to take a case, we will do our best to provide referrals to say, you know, these are some other attorneys you can call to see if they're able to help. We would love your assistance in growing that list. You know, we have put some names on there, but we're not everywhere in the community. You have a much better knowledge of what resources are available, who's in your community, and who has done an effective job representing survivors. So most of the attorneys that we have on our list are private practice attorneys, which means they would likely charge a retainer. You can always ask about pro bono or ask about sliding scale payment plan kind of deals. So if you have suggestions to add to our referral list, please let us know. We would love to have more. Right now, our referrals are a little bit spotty around the state. When case availability opens up, you know, when we have a family law case that's closed, we will look first to the wait list to see, you know, which case we should pick up next. Okay, so as you have clients who are seeking assistance, just send in their intake and we'll get them added to the wait list. We won't be emailing to say, you know, please send us your family law. We'll just look at what we have waiting. Protection orders and housing law cases. When you're sending us their information, let us know laid and what factors make it hard for the survivor to handle pro bono. I know your advocates help with protection orders every day. So you all have the system figured out. You know when there are cases that are sticky and complicated and hard. So please feel free to give us a call and we will figure out whether we have the time to respond appropriately to that case, okay? And the University of Iowa Student Clinic. So as part of our grant application, we have established this partnership with the University of Iowa College of Law, where there are second and third year law students who work on VAWA and U visa cases to help compile those applications. This partnership is intended to enable us to take on a larger number of VAWA and U visa cases because we'll be sort of handing over the reins to this little army of students. We're actually in very close supervision of that. We're in weekly contact with the students to follow up on how cases are progressing and what are they doing. And we talk to clients before the case starts, and then at the end of the semester we pick up the case to whatever point the students left it to finish it up and submit it. So don't worry, it's not like amateurs are going at these cases, but it means that there are law students who will be in contact with advocates. A lot of the cases that we assign to the students, we try to have them be cases where there's an advocate working with the client, because that's helpful. It gives one more person and resource to help compile all of the evidence for that case and support the client through that process. The students are on an academic calendar, so classes start in September and January, and so our clinic partnership with them starts in September and January. That's why you will sometimes see us emailing out a call for cases in June or July, or just recently I sent out a call for cases here, and we are currently looking for additional immigration cases. Like I said, we are accepting immigration cases year-round, so you don't have to wait for us to request it. All we mean is that, hey, we're getting ready for students. We need a stack of cases to partner the students on, and so we're able to take additional cases at those points in time. So send cases our way. Okay. So as we're working with clients and providing them with legal representation, we really need your help as advocates. We really appreciate everything that you do to help clients stay safe, stay stable, and to work through this process. It can be horribly traumatizing. For immigration cases, clients have to write down a personal declaration where they're describing everything that they've gone through, which can be really difficult. Family law cases are just long and require a lot of interaction, visitation exchanges and mediation or negotiation with the opposing party, and everybody wants the abuser to play by the rules, but we should not really be shocked when the abuser decides he doesn't want to play by the rules. So all of that takes a lot of emotional support, and we really appreciate and lean on you all to help us in providing that. Here we train our attorneys and we provide some of that emotional support. We do listening, we talk to clients about it, we help them strategize about what are their options and what's going to work best. But it never hurts to have more people available to support that client, and so we really look to you all to assist with that. Similarly, safety planning, we talk to clients about it, but you all are experts in helping them do this, so we appreciate your support in that. And then legal fees. We don't have money to help with legal fees, whether that's filing fees for divorce or immigration, or if she needs a physician's exam for her VAWA or whatever. These things have price tags that can be really hard to pay, and unfortunately we just don't have the money to be able to pay them for our clients. So lots of programs have helped in the past, appealing to churches, appealing to community supporters to help clients pay for those things, and we appreciate that support. Okay, so that's the information that I could predict that you might need from us. If you have any questions, you can always give us a call. The ICADV phone number is 515-244-8028, and I've posted here our email addresses, so please feel free to contact us if you have questions. And I don't see my little control panel. I'm trying to see if you all... Okay, does anyone have questions? Okay, I am not seeing any questions. So thank you so much for listening and for joining us today. If anything comes up, please feel free to contact us, and we will hopefully be working with you in the future. Thank you.